So as a company that engages in a lot of its own research and development and its own innovation, how have the changes in the intellectual property laws affected your strategy in this area?
That's a very good question. The recent change in patent laws here in the United States, which are now similar to what other parts of the world have had for quite some time, causes us to be significantly more secretive and significantly, I'll say, more timely in the process of applying for patents. As I know you know, the law is now first to file, as opposed to in the past here in the United States it was first to invent, although the inventor had to be able to prove that she or he were indeed the inventor. So what we're finding is that we're having much smaller groups of people, only on people on a need-to-know basis for the types of development that we do. Of course, all of our employees are tied to intellectual property protection rights, but the bigger the group you have, the more likely there's going to be some extraneous discussion about it. So we have tighter groups of people and technicians, where our internal intellectual property counsel as well as external counsel provide as timely input as they can, and then we get to the patent office more often. I was pleased just this past week to see that Leggett Platt had been recognized again in the Wall Street Journal for being one of the more innovative companies in the country. It also is something that has caused us to refocus on the need to redevelop our existing products. I like to call it cannibalizing our existing products. In so much as somebody else can figure out how to produce a particular spring or a particular widget, whatever it happens to be, a little bit differently, and they file for a patent. And if the patent office, which errs every day, but if they do issue the patent, even though they learned from our product, if they have novelty that the patent office issues a patent on, then we could easily feel some competitive force that we wouldn't otherwise. And therefore, as soon as we develop a new product, before it's done, we have another team or usually it's the same team with maybe some other people involved, trying to figure out how to redevelop it. And so you get this perpetuity of intellectual property. Many times we don't run a product halfway through its patent life before it's completely eliminated out of our offering in favor of a new product. So the change in law is what it is, and we certainly respect it and live by it. It's made it a little bit more difficult than it's been in the past.